Most Americans assume laws change as society changes, but the truth is far stranger. Buried deep inside you. Legal codes or clauses written decades, sometimes centuries ago that were never fully removed. They don't show up in textbooks, and politicians rarely mention them, yet they technically still exist. Some were written for emergencies that never came. Others were rushed through during fear, war, or panic. While many are unenforced, they remain on the books, quietly waiting, raising uncomfortable questions about how much power the law still holds long after its original purpose is forgotten. One of the most unsettling examples involves laws that allow the government to seize private property during times of national emergency. These clauses date back to wartime America, when leaders feared invasion or economic collapse. While modern courts rarely allow them to be used broadly, the language itself remains vague. It grants sweeping authority under loosely defined emergencies, leaving room for interpretation. The idea that property rights could be overridden by an old clause most people don't even know exists shows how the past still quietly shadows modern America. Another hidden clause allows for the suspension of certain civil liberties during rebellion or invasion. This power is rooted in the Constitution itself, specifically surrounding habeas corpus. While it has only been used a handful of times in U.S. history, the clause still exists exactly as written. That means, under extreme conditions, people could theoretically be detained without the usual legal protections. It's a legal relic from a time when survival of the nation outweighed individual rights, and it never fully disappeared. There are also laws tied to outdated moral standards that were never formally repealed. In some states, statutes banning certain personal behaviors remain written into law, even though courts no longer enforce them. These clauses survive because removing them would require legislative effort that no one bothers to pursue. They sit quietly, unenforced but intact, creating a strange legal limbo where something can be illegal on paper but ignored in practice. It's a reminder that law does not automatically evolve with culture. Some clauses were created for industries that barely exist anymore. Early railroad laws, for example, still contain language granting special privileges and restrictions that made sense in the 1800s but feel absurd today. These include rites of passage, land use exceptions, and liability rules written for steam engines and horse-drawn crossings. Though rarely applied, they technically remain valid. Their presence shows how American law tends to pile new rules on top of old ones rather than cleaning house. One particularly strange category involves laws written during the Cold War. Fear of espionage and sabotage led to sweeping legal language about surveillance, loyalty, and internal threats. While modern interpretations have narrowed their reach, the original clauses still exist. Some allow for extraordinary government actions during times of perceived subversion. Even though the Cold War ended decades ago, its legal fingerprints remain embedded in American law, quietly influencing how power can be exercised in moments of fear. There are also forgotten clauses related to wartime, rationing, and price controls. These laws were enacted quickly during World War II to stabilize the economy and ensure supplies for the military. While the programs ended, some of the enabling language was never fully repealed. In theory, similar controls could be revived under the same legal authority. The idea that economic life could be reshaped overnight using old legal tools is something few people ever consider. Some of the most controversial clauses involve immigration and citizenship. Older laws include language that reflects the prejudices of their time, using terms and categories that would be unacceptable today. While courts have overridden many of these provisions, the text itself often remains untouched. It's a legal fossil, preserved not because it's right, but because removing it isn't politically urgent. These clauses quietly remind us that the law remembers eras we'd rather forget. In several states, there are still laws granting extraordinary powers to governors during emergencies. These clauses were designed for natural disasters, riots, or war, but their wording is often broad. They allow executive authority to expand rapidly with limited oversight. While intended for crisis, they raise concerns about balance of power. The fact that these clauses remain largely unchanged means they could be interpreted very differently depending on who holds office. Another hidden area involves outdated censorship laws. Early American lawmakers feared immoral books, plays, and later films. Clauses regulating obscenity still exist in various forms, even though modern standards have shifted dramatically. Courts now interpret them narrowly, but the language itself remains vague and subjective. What was once considered dangerous to society is now commonplace. Yet the legal framework that tried to control culture still lingers in the background. Some labor laws contain clauses written to control workers during industrial unrest. These provisions allowed the government to intervene, break strikes, or force arbitration in the name of national stability. While rarely used today, they still exist as legal options. Their survival reflects a time when labor conflict was viewed as a threat to national order rather than a negotiation between workers and employers. There are also hidden clauses related to military authority within U.S. borders. Laws written during periods of internal unrest allow for the deployment of armed forces under certain conditions. While modern safeguards exist, the underlying authority has never been fully removed. This creates an uneasy tension between civilian life and military power, rooted in laws written when the nation feared collapse from within. Some environmental laws include clauses allowing exemptions during national emergencies. These were meant to balance survival with conservation, but their broad wording has raised concerns. In theory, long-standing protections could be suspended using legal language written decades ago. These clauses show how even well-intentioned laws contain escape hatches that can be opened under pressure. Tax law is another area filled with forgotten clauses. Some exemptions, penalties, and emergency measures date back to wars or economic crises long past. While accountants may know them, the average American doesn't. These clauses can still influence policy decisions, quietly shaping who pays what and why, based on logic that no longer reflects modern economic reality. Education laws also contain relics of earlier eras. Clauses addressing segregation, loyalty oaths, and moral instruction still exist in some legal texts, even though they are unenforceable today. They remain because removing them requires political will that often isn't there. Their presence is a reminder that progress often comes from reinterpretation, not erasure. Some public health laws were written during pandemics that most people have never heard of. These clauses grant authorities sweeping powers over movement, business, and personal behavior. While rarely used, they remain available in times of crisis. The recent past reminded many Americans that old laws can suddenly become very relevant again. Voting laws also hide strange clauses. Early regulations designed to control who could vote included restrictions that have since been struck down, but not always deleted. These remnants sit quietly in legal codes, overridden by higher authority, but never fully removed. They show how deeply history is layered into the legal system. There are also transportation laws written for a world before cars dominated America. Clauses governing animal-drawn vehicles, toll roads, and early transit systems still exist in some states. While they seem harmless, they illustrate how laws accumulate rather than disappear, turning legal codes into historical archives. Some criminal statutes include penalties that sound shocking today. Extremely harsh punishments written in earlier centuries remain listed, even though courts would never allow them. These clauses survive because no one sees an urgent need to remove something that won't be enforced, even if its existence feels unsettling. Surveillance laws are another gray area. Clauses written before modern technology struggle to define privacy in today's world. While updated laws exist, older language sometimes overlaps, creating loopholes and confusion. This legal patchwork shows how innovation often moves faster than the law. Certain financial emergency clauses allow the government to intervene in banks and markets under extreme conditions. These powers were designed during moments of panic and remain available today. While intended as safeguards, they also concentrate enormous authority in very few hands. Even land ownership laws contain strange holdovers. Some clauses still reference territories, boundaries, or entities that no longer exist. They remain because correcting them offers little practical benefit, even though they technically govern modern land use. Communication laws written for telegraphs and early radio still influence how information is regulated. Their language feels outdated, yet their legal force hasn't fully disappeared. This creates tension between old rules and new realities. Some consumer protection laws include clauses that favor industries that were once vital to national growth. These protections linger long after the industries changed, subtly shaping markets in ways few consumers realize. Laws surrounding protest and assembly also contain hidden limits written during times of unrest. While the First Amendment is strong, these clauses allow restrictions under certain conditions. Their vague language leaves room for interpretation during moments of crisis. Many of these hidden clauses persist, not because anyone wants them, but because removing them requires time, consensus, and political effort. Lawmakers often focus on new issues, leaving old language untouched. Over time, the legal system becomes layered, not cleaned. The result is a legal landscape where past fears, values, and emergencies still quietly exist alongside modern ideals. Most of the time, these clauses remain dormant. But history shows that dormant laws can awaken quickly under the right conditions. Hidden clauses in U.S. law remind us that the past is never fully gone. It's written into the rules that govern everyday life, waiting silently. The question isn't just what the law says today, but what it still remembers from yesterday.